Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
My name is Lisa Stam. I'm one of the lawyers here at SpringLaw, and joining me today is my colleague Lexa Cutler.
Good morning, everyone.
So our colleagues, Tiffany and Marnie, spoke about conducting terminations at our webinar last month. So today we're not going to talk about that, about what a reasonable notice period looks like. We're only going to talk about what happens after that termination meeting. So it's why we call it the morning after. So if you are one of our clients, you already know that we are employment and contracts lawyer in our virtual law firm based out of Ontario. Welcome to any of you who are new to our webinars. Please feel free to ask questions throughout the webinar. We are always happy to make this as interactive as possible. There is the slide deck itself is available as a download in the software, so go ahead and download that. And if you'd like any more information about our firm, please come to our website at springlaw.ca and you'll see a variety of resources, including our award-winning weekly blog posts about employment law matters, our free employee contract checklist, our new AI policy is on there as well, that if you want to come and look at some of our DIY legal products, a link to our monthly newsletter, and then we have some other innovative products like an ebook for employees who have been recently terminated as an alternative legal services, which may be helpful to people in your ecosystem. So as I said, Lexa and I are doing our presentation today together. Before we dig in, of course, it's always very important to do a land acknowledgement. So we are a virtual law firm, but nevertheless, of course, we're all still working and living in different areas around Ontario. And we acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. We are lawyers and a law firm, so of course we have a disclaimer. Everything in our webinar today is legal information, not advice. The content on our webinar cannot be relied upon as legal advice. Everything is fact specific, so just reach out to us after if you have any questions. So today we're going to talk about protecting the employee's assets, the employer's assets, talking about the employee obligations post-employment. Alexa will really dig into non-competes and non-solicitations. We're going to talk about references and mitigation, and then wrap up with some key takeaways. So over to you, Lexa, to talk about protecting the employer's assets.
Perfect. Thanks, Lisa. So as we all know, the time leading up to and following an employee's termination can be a bit turbulent. But during these transitional periods, it's important to be mindful of your business's valuable information and data and how to keep it safe. So depending on their roles, employees can have access to important confidential information during their tenure, and an employee taking or disclosing this information can present a serious risk for employers. Examples of valuable confidential information would be customer lists, intellectual property, financial data, etc. So what are the best practices for protecting business information and data security? So first, employers can include confidentiality provisions in their contracts to prohibit employees from disclosing information that is not public knowledge, both during employment and after the employment relationship has ended. A confidentiality provision is in a category of contract provisions called restrictive covenants, which also include non-compete and non-solicitation provisions, and we'll talk about those later in the presentation. If employers would like to have a more robust explanation of what is and isn't confidential and how employees are expected to handle this information and the consequences they may face if they improperly use or disclose confidential information, this can be laid out in a standalone policy or be incorporated into an employee handbook alongside other similar policies such as electronic monitoring policies, social media policies, remote work policies, etc. Depending on the context and the workplace, it may make sense to provide regular training on the confidential information policy and ensure that the information about the policy is clear and easy to access for employees. Now, employees owe a duty of confidence to their employers whether there is a confidentiality provision or not. But having the specifics of what is and is not confidential information will provide clarity to employees and make it easier for employers to enforce their rights should an employee breach their confidentiality obligation. If there's not a duty of confidentiality written down in a contract or a policy, it will be up to the court to determine what is and isn't confidential. The employer's past practices of enforcing their confidentiality provision or policy will also be considered by the courts. So it's important for employers to follow through on their policies and treat each instance of disclosure consistently and implement and maintain the procedures and controls laid out in the policy or the contract. However, the value of confidential information generally stems from its confidentiality. So even if you're able to recover damages from the employee in court by enforcing a confidentiality provision, the value of the information has already been diminished or lost if it's been disclosed or disseminated in the public forum. So another key point is preventing the disclosure of confidential business information before it happens. So another common issue we see post-termination is employees, for any number of reasons, not returning the employer's property or not doing it in a timely manner. This is something we would suggest including in the termination letter and reminding employees of their obligation to return all company property in their possession within a certain time frame, a week, 30 days, whatever is reasonable in the circumstances. You can also ask employees to sign a confirmation that they have returned all company property, including all documents, or deleted all company data from any of their personal devices. So complexities in the remote worker environment, it can be obviously especially difficult if an employee works remotely to get back any laptops or other IT equipment after an employee has been terminated. If someone works remotely, especially if they live far away from the employer's offices, you want to reduce as many barriers to returning that property as possible, such as offering a prepaid shipping package for the property to be sent back. You can also work with your IT provider or your IT team before and after the exit to ensure all property has been returned and to handle the return of the equipment. Beyond the tech, it's useful to think about what other property the employee may have, such as keys, parking passes, physical documents or files, or other tools or equipment specific to your industry or business. Focus on your digital and most valuable assets. As we were just talking about, in this day and age, confidential information is likely an employer's most valuable asset. So while no one wants to lose a $1,500 laptop, focus on ensuring your business's digital and IP assets are secure when an employee leaves. If an employee does not return property, say their laptop, after numerous friendly employer requests, the next step would be to send a more serious, scary demand letter, or eventually bring a claim in small claims court, though that's a step we all want to avoid if we can.
But they are fun letters to write for the lawyer, for sure.
Absolutely. So again, terminations can be a turbulent time and things can get lost in the shuffle. So employers can create standardized post-employment tech procedures. You can create a workflow or checklist of everything that needs to be done pre and post termination, including removing employee access to their email, servers, and files. You don't want any important steps to be missed, and you can reduce the likelihood of any disclosure of confidential information by ensuring that access to employer emails and files is cut off promptly for departing employees, especially in those moments where emotions can be high. Standardized workflows also ensure that all employees are treated consistently so that one employee doesn't feel as though they're being treated harshly by the employer and therefore more likely to bring a claim of bad faith termination, for example. If you cut off one employee's access to email immediately after termination, you should cut off all employees' access to email immediately after termination.
Okay. Thank you, Lexa. Yeah, the confidential information really is some of the most important to really be focusing on. So we are going to talk a bit more about that. Yeah, you heard an echo, didn't you, Lexa? So are you hearing an echo with me right now, or we're good to go? No? Okay. Okay, so I'm going to talk about employee obligations post-employment. So employees do have residual obligations post-employment, sometimes because it's in a contract, sometimes because it's in a statute somewhere, and sometimes because of common law or what a court would impose. So we'll talk through that. So I'm going to talk through what are the employees' big picture legal obligations post-employment. What are some fiduciary duties? Do they have fiduciary duties? And really only sometimes and not that often, actually. We'll talk a bit about confidentiality, mitigation, and then go through what can be put into a release. So what are an employee's obligations post-employment? So Lex is going to talk a lot about non-solicitation and non-compete obligations in our next section. So I'm going to not talk about that. I'm going to talk about the other legal obligations. So whether your employee has resigned or been terminated by the company, the employee does always have certain legal obligations that will continue to flow post-employment. The full range of these obligations really turns on how much you get into that release and how much the parties have contractually agreed on. So if there's no release, well, that happens if the employer resigns. Typically, there isn't a release engaged at that point. Or if the employer, if you terminate an employee and only give them ESA, only statutory minimums, or the employee is fired for cause, in those situations, there's typically no release. So if there is no release, no settlement package and no release engaged, then the common law will still continue to apply, and the obligations that an employee may have will come from common law. So these include fiduciary duties, the duty to keep information, to keep confidential information confidential, and mitigation. So these are all, these post-employment obligations are typically, most of them are referred to as restrictive covenants, as Lexa has already referenced to. And it really is about restricting an employee from doing something afterwards. And she will go into the rationale around that a little more in her section about non-competes, which we're seeing really challenged in the courts right now. So let's talk about fiduciary duties. This is a term that actually has a pretty narrow application in the world of employment law. There's actually few employees that are legally or actually defined as a fiduciary employee at law. It really, but once you can get an employee characterized as a fiduciary, then there is this much higher standard and level that would apply to their post-employment obligations. So who's an employee? Who's a fiduciary employee? Usually a fiduciary employee is an employee who can exercise unilateral power or who has control or discretion on affairs that affect the employer's interests. So most of your employees are not going to be a fiduciary. Most of them are carrying out their job, and the employer isn't at the mercy of that employee's unilateral discretion. So really you're talking about C-suites, people in very senior level roles who are going to be deemed a fiduciary. We tend to attach it a little faster to people who have key access to money or accounts or the financial business of the organization. So it often is easier to have your CFO deemed a fiduciary than some of the other roles, for example. The rationale behind all this is if your employee is actually a fiduciary in the company, then that the employer is now vulnerable, and that balance of power has shifted. And the common law will step in to help protect this power imbalance and may impose some post-employment obligations. So what are these fiduciary duties? They include things like a duty of good faith and loyalty or fidelity. So not if they are a fiduciary during employment, not working for a competitor, for example. But post-employment as well, that level of good faith and not undermining the employer really starts to kick in. There's a legal duty, not to misuse or reveal confidential information or trade secrets during or after. That is a fundamental obligation of all employees, but there's an elevated weight to it for your fiduciaries. There is a duty not to actively solicit customers or employees during, and then for a reasonable amount of time after. And this is one of those fun lawyerly phrases. Reasonable amount of time is subject to all kinds of case law, but that fiduciary duty will continue post-employment by default for at least a reasonable period of time, unlike your non-fiduciary employees. So whether the fiduciary is a fiduciary will really turn on the actual role, not on their title or whether they're a contractor or employee, although typically your contractors will not have that duty of fidelity and exclusivity in their contract or that relationship, but that the fiduciary itself will, like many employment relationships, the court's going to look at what is this person actually doing. Okay, let's talk about confidentiality. This is an employee obligation that is, I would say, is probably one of the most important things to emphasize and really work on. It is probably one of the most powerful hooks to hang your hat on post-employment. So even if your employee is not at the level of a fiduciary employee, if they have access to confidential information, they do have a common law duty to keep that confidential information confidential. So what is confidential information? This is obviously what all the battle will be about. Is this confidential information or not? It has to be information that's very specific in nature, that's not generally known to the public, that's communicated to the employee on a need-to-know or confidential basis so that the employee knows it is confidential and that it's treated as confidential by the employer. So I know Lexa talked about that in the previous section, but just wrapping that all together, this is an important thing for employers to protect, but it is this obligation that employees have post-employment. So all employees do have this continuing obligation not to misuse an employer's confidential information. Now, some stuff is not confidential information. So an employee always has the right to use their knowledge and skill that they would have acquired at a job with a former employer in their new job, as long as they're not misusing that confidential information. So if your employee has learned a bunch of fantastic skills or knowledge in your organization, it's almost impossible to prevent an employer or an employee from not using that in their next job because of all kinds of public interest reasons. So for a non-fiduciary employee, they are entitled to work for a competitor afterwards. They can solicit past employers and employees if you don't otherwise have some sort of release or contract in place that restricts that for a period of time. It's a free market. I mean, this is the public interest piece. So the parties can enter into a contract about what will be protected and what an employee can and cannot do afterwards. But that's part of that negotiation where an employer really needs to be ready to pay some money in exchange, in that termination package to the employee in exchange for the employee being restricted in some way. Certain roles are going to be very more important for an employer to really protect. So your salespeople who have access to all kinds of lists, your finance people who have all kinds of access to your financial information. And that's where you really will want to consider putting in some sort of restrictions into their release, which are really the non-solicit, non-compete provisions, which Lex will talk about in the next section. So let's talk about mitigation. This is another employee obligation that flows post-employment. It is a double-edged sword for employees. So our firm represents both employers and employees. And when we're on for an employee, we talk a lot about mitigation with them because, and that could be a whole webinar topic unto itself. It can really gut an employee's case. It can if they get a fantastic job, a month into their 12-month notice period, unless there's some clarity in the release, it could be that there's going to be some sort of clawback provision in there. So we've written lots of blog posts on this, so come to our website and ask us as well if you have any questions about mitigation. But this one is probably one of the most critical obligations that an employee has post termination. So what is it? Basically, if an employee wants to claim for more than their statutory minimums or more termination pay than what their contract says, or if their contract's set aside, which does happen quite a bit these days, a court will take a look at, here's what the reasonable notice period should be, that's the common law amount, and then here's the amount of cushion this employee needs to get to the next job. If that employee does find a job sooner, then they didn't need that full cushion. And so a court will step in and say, well, you mitigated your losses. So now we're going to set off the total amount that we initially thought you needed as a cushion to get to your next role, and set off the amount you made at this new employer. And so that, and it means that the original employer who did the termination is on the hook for a lot less. So it can really have a really important mathematical consequence for both. The idea is that termination pay is not intended to be a double recovery or a windfall for employees. You're to be covered for a period of time, whether it's your former employer or if you happen to get a new job. If there's no reference to mitigation in the termination package, then the employer can't do a clawback without agreeing to it. So it is something to include in the termination package itself. It's a very powerful tool, and it can be a really important point of negotiations in the whole process. You'll often see, for example, when we're on for the employer, that all of a sudden the employee is super engaged and trying to settle something out quickly, and they're all of a sudden compromising a lot more. It's likely that they're down the road on some great interviews and are hopeful they're going to get a role, and they want to close a deal before they get that new job and mitigate. So it really plays a lot into the strategy around all of it. So that's an employee obligation post-employment. The other obligation post-employment is really whatever the parties put into the release. A termination package is essentially a new deal between the parties. The employment agreement is all the stuff that happens up to termination, and then some, quite a few terms that will impact what the termination package will look like. But then we all agree when we sign off on a fresh release or minutes of settlement, this is what the termination package is going to be. And that is a creature of negotiation. So, as long as you don't go below minimum standards or below the contract, there's certain floors and ceilings to it all. But the parties can negotiate some very specific terms depending on what is needed by, or what is, triggered by the industry or by the individual or the workplace. We're increasingly seeing things like employees are being required to update their social media feeds, for example, to indicate that they're not with the company anymore, or to keep it on a period of time while the employer looks for new work, or a new employee, to signal stability to the industry, for example. It's a more minor example, but you can definitely negotiate terms about what things should look like post-employment. So those are employee obligations. That should have been about 5 slides instead of 1, but I'm going to pass it back over to Lexa for non-competes and non-solicitations. And again, just if anyone has any questions, feel free to ask them as we go. Oh, Lexa, check your mic. It's she knows how to fix it, but there's some weird thing happening there.
Can you hear me now?
Yeah, you're good.
Yeah, you're good. Perfect. All right. Thanks, Lisa. So non-compete and non-solicitation clauses are restrictive covenants, which Lisa and I have both mentioned already, just like confidentiality provisions. So those are all restrictive covenants. So they're called that because they seek to restrict what an employee can and can't do after the employment relationship has come to an end. So the difference between these two restrictions: non-solicitation clauses prohibit employees from soliciting from their former employer's clients or other employees to leave their employer's business, whereas a non-competition clause prohibits an employee from engaging in a competing business at all within a given geographic area and during a specified time period. So non-solicitation clauses have always been easier to enforce than non-competes because a non-compete can interfere with an employee's ability to earn a livelihood. For instance, if someone is a dentist and their contract says that post-termination they can't work as a dentist for 2 years in the province of Ontario, it's going to be pretty difficult for that person to earn a living. And courts do not look kindly on employers who try to interfere with their employees' livelihoods in that way. So it is really a public policy rationale behind that. Conversely, a non-solicitation clause in that same example could say that a departing dentist can't try to solicit or convince any of their patients to follow them and leave their former employer. And they can't try to convince other dentists or dental hygienists or admin staff to leave their former employer and follow them. So that's the distinction there. Perfect. So first, let's talk a bit more about non-competes. So here on the screen, we have the definition of a non-compete agreement under the Ontario Employment Standards Act. So a non-compete agreement is defined as an agreement or any part of an agreement between an employer and an employee that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business after the employment relationship between the employee and the employer ends. So effective October 25th, 2021, employers are prohibited from entering into non-compete agreements with employees under the Ontario Employment Standards Act. The ESA does not prohibit non-compete agreements that were entered into before October 25th, 2021. So any of those legacy contracts are still good, but these still need to be reasonable under the common law in order to be enforceable, which we'll talk about more, is a really high bar and hard to meet. Doesn't happen very often. So the blanket prohibition under the ESA to non-compete agreements has 2 exceptions. So the first is with regards to the sale of a business when all 3 of these criteria are met. So if there is a sale of business or lease of a business or part of a business that is operated as a sole proprietorship or partnership, if immediately following the sale, the seller becomes an employee of the purchaser. And 3, as part of the sale, the purchaser and seller enter into an agreement that prohibits the seller from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the purchaser's business after the sale. So it's a very narrow business circumstance is the first exception to the ban on non-competes. The second exception is for executives. So employers can enter into non-compete agreements with executives such as anyone who holds a C-suite position, so CEO, CFO, Chief Operating Officer, Chief Legal Officer, or a president position. So those really high level positions in an organization. So in both of these exceptions, the ESA and the Ontario government are acknowledging that these employees, either the former business owner or the executive, are more likely to have equal bargaining power with their employer. So they're not as in need of protection as a regular employee. These amendments to the ESA are consistent with the court's interpretation of non-competes at common law, which is that they are generally contrary to public policy and unenforceable. So, can an employer ever enforce the non-compete clause? That's a good question. So, even if a non-compete clause is not prohibited by the Ontario ESA, either it was one of those legacy contracts that was entered into before October 25th, 2021, or if one of the exception applies, or if the employee is outside of Ontario, so no other province other than Quebec, I believe, has these same restrictions on non-competes. So non-competes, even if one of those doesn't apply, non-compete is still generally unenforceable, apart from very exceptional cases. where based on the circumstances, the employee had such knowledge and influence over the employer's business or customers that they could take advantage of their connection to undermine the employer's business. So a non-compete clause is more likely to be upheld where the employee was the face of the business, or where there's more equality of bargaining power between the parties. So if there's any hope for a non-compete clause to be found reasonable and therefore enforceable by the courts, it must be clear and unambiguous. So that means an employee must be able to tell from the clause exactly what they can and cannot do. To make things more clear, employers can avoid using boilerplate provisions and cater them to the specific employee. They can define important terms and make sure that the clause is consistent with the contract as a whole. An enforceable non-compete clause must also be linked to the protection of the employer's legitimate proprietary interests. So employers can't just use non-competes for the sole purpose of preventing employees from competing. As Lisa said, we're allowed to have competition in the marketplace, but there must be a valid business reason to justify it. So a legitimate proprietary interest would be to protect client relationships, goodwill, or trade connections. But if that's the purpose of the non-compete, employers should really think about whether a non-solicitation clause, so preventing employees from soliciting those clients, would accomplish the same goal, as the non-solicitation clause is more likely to be enforceable and less likely to impact the ability of the employee to earn a livelihood. So an enforceable non-compete clause must also be as minimally restrictive as possible with time, geography, and activity. So time, the goal of the restrictive covenant is to give the employer reasonable time to secure its relationships with its customers or to transition the terminated employee's customers to whoever their replacement is after the employee has departed. So the scope of non-competes must be limited to the amount of time it will take for the employer to achieve this goal. Only in very exceptional cases would a court uphold a non-compete for longer than, say, 12 months, and typically 6 months should do it. Next, looking at geography, the smaller the area that is covered by the non-compete, so not putting all of Canada, but Toronto, the GTA, whatever the specific market or niche is of the employer, the more likely it will be upheld as reasonable. And finally, the activities being restricted must also be reasonable in the circumstances to protect the employer's interests. For instance, if the employee was in sales, you shouldn't be restricting their ability to sell or engage in the sale of anything. That would be extremely onerous. Instead, it should be catered to the employer's specific business as narrowly as possible to protect the employer's interests. So the courts always want it to be as minimally invasive into the employee's ability to earn a livelihood as possible. So the more specific you can make it, the better. Ultimately, if an employer has spoken to counsel, they know that any non-compete clauses are likely to be unenforceable in court. And employers aren't keen, typically, to actually pursue legal action if an employee were to breach a non-compete provision. Many employers instead use these provisions as deterrents for terminated employees, though they never intend to actually rely on them. This is a strategic choice, but could be dangerous, as the trend of recent case law, as if you've read our blog, you'll be very familiar with. The trend of recent case law is that any contractual provisions dealing with termination that are unenforceable can invalidate all termination-related provisions in the contract, opening up employers to huge liability. So it is a risk to include a non-compete, and employers need to weigh the value of having a non-compete with the reality that they are unlikely to be enforceable and could put the enforceability of the contract into jeopardy. If you want to enforce a non-compete clause, one of the main ways to do this is by bringing an injunction, which is a court order which compels a person to do or not do something, but these can be time-consuming and difficult to obtain. So, like I said, non-solicitation provisions are generally more likely to be enforceable than non-competes, but courts still do find non-solicits to be unenforceable much of the time. The same considerations apply to non-solicitation provisions as non-compete provisions to determine whether or not they're reasonable. So again, they must be clear and unambiguous, linked to the protection of a legitimate proprietary interest, and be reasonable in terms of geographic scope, temporal scope, and the activities being restricted. Geographic scope is less likely to be relevant in non-solicitation cases, particularly if the rest of the provision is appropriately narrow. Non-solicits should identify the specific customers or employees that are off limits for solicitation. So they're more likely to be upheld if the clause is limited to the actual clients or customers that the employee actually managed or serviced. And it should be limited to clients or customers at the time of termination, as in not every single client the employer has ever done business with ever. That's going to be too restrictive. If the employee brought over clients when they started with the employer, those should also likely be excluded depending on the industry and the terms under which they came over. Courts also tend to distinguish between active solicitation and passive solicitation. So actively calling or emailing clients to solicit their business versus the employee making a general announcement that they're starting a new job or a new business, that would be seen as more passive. So what isn't and what isn't solicitation depends on the employee's role and their industry. For instance, certain professions, like particularly regulated professions like financial advisors or lawyers, may have a duty to inform their clients when they're leaving their employer and give the client the option to stay with the employer or to follow the employee wherever they're going. So it's unfortunately difficult to predict what will and won't be considered solicitation, as it's always heavily dependent on the specific facts and circumstances of the employee and their role, and the employer and their industry or business. It's also worth noting that courts have not allowed employers to rely on non-compete or non-solicitation clauses if the employee has been wrongfully dismissed, because the employer is not allowed to rely on the contract while also breaching the contract. So, and if an employee is making a constructive dismissal claim or a general wrongful dismissal claim, the employer then can't turn around and try to hold them to the non-compete or non-solicit in their contract. Ultimately, non-competes and non-solicitation clauses are one legal tool in an employer's toolbox to protect their interests after the employment relationship has ended. But just because a clause is there does not mean that it will be enforceable. Also, the process of actually enforcing the clause through an injunction or seeking damages can be costly, time-consuming, and risky. So it's always going to be an important strategic consideration to determine if one of these clauses should be used and if they should be enforced.
Awesome. That was such a good summary. Everything around solicitations. It's definitely a shifting area of law that's hard to, especially in our world of the online economy, where geographic scope is kind of out the window in a lot of people's business. I see some questions coming in. One of them is a question that I'm afraid I don't actually know the answer, so, but I want to acknowledge that. Have other provinces banned non-competes as well? So Ontario does have this specific legislation that came out in our Employment Centres Act a year and a half ago. Other provinces, some have, but not all, and I just don't know off the top of my head. If you are, and Lexa, if you know, jump in. But for anyone who has an American parent, so a company, if you're an operation in Canada with an American parent, I know it's starting to roll out in certain states. California started with really just knocking out non-competes generally. So, but the legal landscape is just so very different that the impact of these non-competes just roll out in a very different way. So if you have an American parent, you'll also need to reconcile probably the advice that you're getting from them. Another good question here, and I'm going to pass this one over to you, Lexa, to answer. Is it best just to omit a non-compete altogether in an employment agreement unless it's for a C-suite type role?
Yeah, so now in Ontario, absolutely, it's contrary to the ESA now for a non-executive employee for an employer to put that into their contract post October 2021. So moving forward in Ontario, it should only be executives. In other provinces, it will be, so Lisa, I'm pretty sure that it's only Ontario and Quebec that have this statutory limit. So in other provinces, it's going to be that same thought process that I was just walking through. So it should still likely be only fairly high level employees, and only those that have that, you know, a lot of face time with clients, really strong relationship with clients, or some sort of special relationship to the business that are going to be worth taking that risk of including a non-compete generally. But it does really depend on the specific facts, not to be too lawyerly on that, but it really does depend. But yeah, in general, still, even if it's in a province where there isn't that statutory limit, it's still going to be those higher level employees are going to be where it's actually worth it to include a non-compete generally.
And I mean, to that point, and those are the employees where it will be worth it to fight about it after as well. So, I mean, if you are running a grocery store and one of your tellers goes down the street and works for another grocery store, who cares? No one's going to fight over that. But if it's, you know, you're a software company and this is a key software engineer or salesperson, especially that has all the secret sauce, you're likely to fight over it. I find the non-competes in particular a bit of a mathematical situation for many workplaces. Another question we had that related to the mitigation comments that we made earlier, and we're just getting to it now. This is a great practical question that I think it'd be good to address. So the question is, we have a former employee who signed a release upon termination confirming she would let us know if or when she finds suitable employment for the purposes of initiating our termination clause, our termination pay clawback clause or mitigation clause. She has not told us if she's working, but we believe and assume she's that it is a reasonable replacement job. What recourse do we have for her potential lack of cooperation? So I would say the first thing is put the question very directly to a past employee, ideally in writing, definitely in writing, in fact, and just put it to them. Have you found comparable work, or have you found another job? You know, and ideally trace the wording in the termination package that you that she signed off on, or that they signed off on, and put it right in there. You know, have you found work? And if they then deny this in writing, you know, you start to go down the road of them breaching their end of the deal. And if you are doing a salary continuance in particular, you can turn off the tap if you understand this former employee does have a comparable job. I have to say that I would never turn off the tap quickly, and I would be very careful about all of that and get some confirmation, have a phone call, you know, do a few things. Typically, these conversations with past employees are super awkward and no fun and not terribly amicable. But if they have signed off and they have, you mentioned reasonable replacement, but I don't know whether you meant comparable or similar or equivalent. There's a bunch of different adjectives that we can use in this case. Reasonable replacement is a little bit broad. What's reasonable to the employer may not be reasonable to the employee. Words like comparable or equivalent are cleaner to address. So if they find a job, especially if the salary is pretty similar, then I would just, as a start, get some sort of confirmation in writing for them. And if they're still dodging it, then you would go down this other path of now they're lying. Now they're lying and being dishonest about a contractual obligation. It's 11:15. Let's go on to the final topic here, but keep asking some questions as we go along here. Let's talk about references and mitigation. So should you give your exiting employees a reference? Employers are under no obligation to provide a reference, but should you? And not providing a reference, if it can prolong an employee's job search, does it increase their damages? So Canadian I have to say, first of all, Canadian law really approaches this very different than US law. So if, like I said earlier, if you work for a global company with a US parent, you will likely be told, do not give references to your employees, because there's this fear of getting sued for misrepresentation in the US. It is just not a thing in Canada. It is not going to happen. There are actually many, many good business reasons, let alone good human reasons, to give references where you can. It's important not to put the company in the position of giving a dishonest or inaccurate reference, but there's almost always something nice that you can say about this person, even if you might sort of avoid some of the areas where they were not skillful. So references are important because it can really help that employee find work. And so by not providing a reference could extend the reasonable notice period this employee needs to find another job. And the win-win here for both employee and employer is that we all help that employee get to their next job as quickly as we can. It shortens that cushion that they need at common law. It brings down the temperature overall. And if the employee can re-employ fairly quickly in a comparable role, they tend to be less resistant to a reasonable compromise if you're still negotiating a termination package, for example. It may hinder the employee from just moving on and really hinder being able to have calmer discussions about what a settlement can look like. The employer could be exposed to bad faith claims of bad faith in the termination process if the employer is playing particularly difficult hardball. And you see that a lot in the case law, that this employer was engaging in hardball tactics with their past employee. And that includes situations like this where if there's no reason not to give some sort of reference and they're declining to do so, you really will want to have a good reason. If this is an employee who was fired for cause, in one of those rare cases where you can actually establish cause, and they were a horrible human being and stole money and lied to everyone and were terrible, fine. You don't need to give them a reference. I understand that. But for most of the time, you really are, there's a win-win benefit to giving a reference letter. So I'm as you can tell, a huge proponent of this. Another good strategy for employers as part of the settlement discussions is to invite the employee to draft their own reference letter, not to pass the buck at all, but that employee is more likely to know what skill set they want emphasized to look for their next job. And so it's just a practical way of letting them really craft something to have some agency in what that letter might look like. It can be cathartic for some employees to just be able to, reflect on all the good things that they did do in the role, feel more in control of their own future. So there's some employee psychology around this as well. But practically, it will no doubt be way more glowing than the reference letter that your kind of lukewarm manager, who's probably too busy and has moved on from this whole situation, it'll be more glowing than what that person may actually say. So it is a way of crafting this win-win. Again, I think there's nothing wrong with then going in and editing that employee's draft a bit if you need to probably tone it down a bit or remove some things that are inaccurate. But if we can help that employee get to the next job, it contains the exposure of the liability for the employer. So it really is a win-win. What about confirmation letters? So we often, or letters of employment, we're seeing more of that. And I think almost always it's because it's a global company with an employer outside of Canada, where they have just across the board rules that we're not going to do reference letters. And so but they will, provide those letters that say, Lexa worked at SpringLaw from this date to that date, and this was her role, and no commentary at all. I don't know. It shows that they worked at your organization, but it doesn't help a person find a new job. And I would say from a practical point of view, they're fairly useless to an employee, unless they're maybe like applying for a bank loan or something and they just need evidence that they worked somewhere. But it's not helpful if there's nothing positive in there. Everyone reads through that right away. So it's something to consider practically, to really consider reference letters and proper reference letters to as that win-win. Some other things to think about when you are providing a reference to your exiting employee, some do's and don'ts. So do find something positive to say if you can, and true. I mean, absolutely, this has to be completely honest. Do say if the termination was because of downsizing or business reasons. That it can be very helpful to an employee to just establish that there was no questions about their performance, that it really is just a restructuring type of thing. Provide it right away so they can actually start mitigating. Ideally, don't make it a condition of them signing off necessarily, because you want to do all you can to get them to their next job. And I think overall being negative is not going to help any sort of settlement discussions. Can an employer reduce that termination package if the employee finds a new job quickly? So what is this duty to mitigate? We talked about this a bit already. The law does require terminated employees to mitigate their damages. They have to actively attempt to reduce their economic losses. So that is all baked into our case law generally. So how do you handle this? It's this clawback clause that somebody asked a question about already, and that we've talked about. But you include in the termination clause or in the termination package, the letter, that if they find alternative or comparable employment, I like comparable employment. If I'm on for the employee, any employment, if you're on for the employer, if they find another job that they'll, that the income they make from that gets set off, or that their remaining termination pay, especially if it's on salary continuance, a portion of it will be clawed back. It's important to explain this very clearly in your termination letter. Ideally, have it in your employment contracts up front, so it's just part of the best practices of the organization. Can an employer reduce the package if they find the role quickly? How do you help soften an employee's landing? And I think this is all interconnected. Reference letters, like we said. Outplacement services, we definitely see that more and more all the time. It is not just a nice and good thing to do, but again, it's this win-win where if you can help an employee land a new role, it just settles the temperature so much more. Make introductions, rely on recruiters. So do those things to help out, and then include this mitigation clause. For takeaways, let me just see if there's any other questions here that we wanted to talk about. There was one in here about retro pay that's very specific to a collective agreement environment and to a specific clause in a collective agreement. So I'm going to deliberately skip over that, just because I think, Michael, if you want to reach out to us directly, we can chat about that. But I think it's too specific to a specific set of facts to really talk about it. Okay, yeah, and then so it was the mitigation clause question. In that case, it was about 75% of pay in a similar role was the deal. So that's very common. And so 50%, 75% for these mitigation clauses, that's all quite common. So that you should be able, if it's a similar role and they have found a similar role, then that's when you can start doing the clawback. It's why I really like salary continuance. It makes it practically much easier for a couple of things. It allows you to keep benefits going, and I always am a huge fan of keeping benefits going as long as possible. It's a very cheap give given the exposure if things do go south on a health front, but it also gives the employer that control over the mitigation clause if you do have that in place. Okay, I think that's all for now. Let's move over to our takeaways. As Lexa explained, it is very important to focus on your digital assets more than your physical these days. I mean, who cares about your $1,200 5-year-old computer that probably isn't worth much? It's the information on that. It's the digital data on there. It's your servers. It's your, it's confidential information. It's client or customer information. It's all that, your R&D. It's all the digital information that is of the often now the greater value. So when you're dealing with any of these post-employment steps or restrictive covenants, really focusing in on digital is probably one of the most important pieces. Lexa, I'm going to turn it over to you to finish up the takeaways. So.
Oh no.
It's good.
Good?
No, it's good.
Okay. Awesome. Yeah, so sabotage is rarely a live issue. I know that can be employers' worst fear when terminating an employee, but generally you can assume that the parties want to end with grace, and you can treat exiting employees with respect. And this is also going to be better for business and protect you from, again, if something does turn into a wrongful dismissal claim and all of the employer's actions come under scrutiny, you want to be on the side of the angels on that. So it's usually better, unless there's some specific concern or circumstance, to assume that everyone is operating in good faith. You want to include your post-employment obligations in the termination letter and release. So as Lisa said, it can also be really helpful to include that in the contract, just so everyone understands up front what the expectations are, but you really do want to reiterate that in the termination letter and release, because it is a fresh contract that you're entering into. So it will be a lot more difficult to rely on those if they're only in the contract. It will be just make everything simpler if you're reminding the employee again and including those in that fresh contract. You want to focus on restricting taking clients or employees rather than preventing exiting employees from working. So that was our whole conversation about non-competes and non-solicits. The non-solicitation clause is more likely to be enforceable, and essentially for most roles is going to be just as valuable and still accomplish the same goal as a non-compete, except for those very narrow circumstances. So that can be a much better and more likely to succeed way of protecting the business's interests. And finally, be nice with references and help an employee to mitigate. It's a win-win. Helping that reduces the employer's liability and is a nice human thing to do. Everybody needs a job, and generally we all want these departing employees to have a soft landing and to find another job. So it really helps everyone to just provide that reference up front.
It is the most Canadian. I would have to say it's be nice even when you're firing people. So that wraps up our presentation. Thank you. If you have any questions, absolutely come and reach out to us. Come to our website. Here's our different lawyers. Feel free to reach out to any of us. Our next webinar will be on November 15. I will be co-hosting with one of our newest lawyers, Ben Curry, who just started with us a few weeks ago. So I'm very excited about that. Again, come to our website to register both for the webinar, sign up for our newsletter, and just stay up to date with employment law updates through our social feeds, our Facebook, Twitter, LinkedIn, Instagram. We've been on our TikTok. We're still getting that one going, and our quite populated YouTube channel at this point. Thank you very much, and we will see you next month.